It did go
This
away.
is case number, all right, this is case number 21-151422. This is Enhanced Center Individual Spine and Sports versus Allstate Insurance. The matter is before the court, set for a status conference scheduling conference on today's date. Your appearance for Enhanced? Any appearance for Enhanced Center? Any appearance for Allstate Insurance?
Yes, Your Honor. This is my name is Robert Fix. P number is 37458. On behalf of Allstate, Your Honor, I just got an email here. Richard Brewer from Falzone and Wygod was the attorney who filed the complaint, and I just got an I emailed him about 15 minutes ago about the hearing, and his email just came back saying this was not on my calendar. It's not on his file list. So I don't know if you just want to give us an adjourned date or if he's going to check on. I gave him the Zoom contact info. I'll leave it up to the court's discretion.
All right, thank you. Thank you, counsel. So I know that you are defendant in this matter, representing defendant. Do you have any scope as to what might be necessary by way of discovery and pretrial type issues in this matter?
Yes, I mean, we would need, we'll have to exchange discovery because the complaint only indicated dates of service. The complaint was silent as to amounts, so I do not know the amounts. We may need to take the biller's dep, and once that's done, then we could possibly, go from there.
All right, a 60-day horizon for discovery sounds reasonable to you, counsel?
If I could ask for 90, because I know I have a 2-week vacation coming up and I'm pushing everything afterwards.
That's what I'm trying to avoid, these vacations. All right. I guess I'll be a little bit of a sucker for it. All right, so I'll grant 90 days, 90-day window for discovery. Discovery will be granted through August the 20th. I don't have the August calendar.
Yeah, August 20th, yes.
Through August 20th. With regard to the exchange of witness list, the exchange of witness list has to be made 2 weeks after the close of discovery, within 2 weeks of that time. And Madam Clerk, that date is going to be September, 2 weeks in.
You want September?
Yes, 2 weeks after the 20th of August.
Okay, so we got the 20th of August. We're talking about September the, want to do September 2nd?
September 2nd, 2021. Any motions must be filed on or before that date as well. Motions filing on or before the 2nd of September 2021. Motions timely filed in this matter will be heard on October, what's the first Thursday in October?
The 7th.
October 7th, 2021 at 9:00 a.m. All right, the court has generated a pretrial scheduling order, and I will make sure that a copy is sent out to the attorneys in this matter. And counsel, if you will chat an email address, we'll make sure that we email that out to you right away.
Okay, my email address is rfix and the number 1. So rfix1@allstate.com.
All right. I was hoping you could put it in the chat, but do it one more time, sir.
Oh, I'm sorry. It's rfix and the number 1. So rfix1@allstate.com.
Yeah.
Mm-hmm.
All right. We'll get that right over to you. And if you will, counsel, advance it to the other side. We will be mailing out that copy to them. But if you will forward one, that would be great as well.
Okay, and you're just to make sure that October 7th date is both a motion hearing date, if any are filed, and a pretrial date?
And a final pretrial conference date is set for October 7th, 2021.
Yes, at 9. Okay, all right. Thank you very much, Your Honor. I appreciate it. You stay well.
All right. Thank you, sir.
Okay.
The last Thursday.
last Thursday is the 29th.
I'm sorry.
The 29th.
Thank you. All right, the court now calls case number 21-61683. This is Jefferson Capital System LLC, assignee of DT Energy versus Jessica Tyler. The matter is before the court on filing of a general civil complaint for the, today is the date and time set for a virtual hearing regarding final pretrial conference, it looks like, regarding this matter. Your appearance for the plaintiff.
Good morning, Your Honor. Zachary Chewy appearing on behalf of plaintiff P83966.
All right, thank you, counsel. And I'm looking for Jessica Tyler. If you're on the Zoom, please say something at this time, ma'am. Jessica Tyler. All right, I have received what was in the nature of an answer in regard to this matter. It says, Your Honor, I'm responding to a letter received from plaintiff. Unfortunately, due to COVID-19, I'm not working full-time. I can't afford to pay the full amount, which is $3,339.22. Since if possible, I would like to be placed on a payment plan paying $20 per month. And it looks like the defendant is not here. Ms. Tyler, once again, if you're here, please say something at this time. All right, counsel, your position regarding this matter, sir.
Given that she has already admitted to the liability and that she's not here, I would either ask that we enter a default or grant the motion for summary disposition we have.
All right, I will, at this time, grant the motion for summary disposition was properly submitted on this date, which is the date set for hearing on the same, finding that there is no disputed issues of material facts, and that therefore judgment should be granted by summary disposition. The court will assign an order consistent with the same upon its presentment. Does counsel wish to address the request to be allowed to pay the judgment at $20 per month at this time?
Not at this time. I think we'll speak with the defendant and hopefully come up with payment terms. So we'll just do a regular judgment.
Very well, counsel. Judgment will be entered as prayed, and you can submit that electronically, sir. Did you take the information down already?
I have not, no.
And that's a tip off to everybody else that's on here. So that's Latifah, LATIFAH .hunter@36districtcourt.org. Thank you, counsel.
Thank you, Your Honor. You have a great day.
Likewise to you, sir. The court now calls 21-57502. This is Roberts Orthopedics Services PC versus National Union Fire Insurance. The matter is before the court for a final pretrial conference in regard to this matter. It is also set for hearings on motions. There is a motion for summary disposition that is pending before the court at this time. All right, your appearance for the plaintiff, please.
For the plaintiff, Your Honor, first of all, good morning. Michael Fortner. I represent Roberts Orthopedics. How are you this morning, Your Honor?
All right, good morning to you, sir, and thank you. For the defendant in this matter, your appearance at this time.
Good morning, Judge Caitlin Milroy on behalf of Defendant National Union, P number 79022.
All right, thank you, Ms. Milroy. And before we address issues regarding the motion here, have there been any discussions that might result in this matter being resolved short of any decisions that might be made by this court?
Not at this time, Your Honor.
All right, very well. You may proceed at this time in relationship to your motion, Madam Counsel.
Well, let me just interject for 1 second, Your Honor, with the court's permission. Kelly, I don't have the motion, so I haven't filed a response. I don't even know what the motion is about.
Judge, if I may, this motion was actually originally filed by mistake within the 30th District Court, if Mr. Fortner will recall. And Mr. Fortner's office actually pointed out that mistake back in September. And so we had refiled the motion before this honorable court in October. You should be well aware of this motion.
Yeah, I'm looking at the motion now. Yeah, we had it in it. But let me ask you a question. Did I file a response to this motion yet, Caitlin?
You did not.
Yeah, can you put us in a breakout room just so I can get a handle on what this motion is about?
All right, let's do that.
Let's see what was refiled in 36th District, Caitlin. I do have a copy of the one that was filed in 30th. What is it, a 1 year back motion?
It is workers' compensation being highest priority.
Okay, yeah, let me take this. Yeah, put us in a breakout room. Yeah, let me take a look at it real fast.
All right, just one
All
minute.
right.
Get
Thanks,
that set
Kevin.
up. All right. All right, I've assigned you to breakout room one. You may proceed there, and I'll stand down until your return.
Thank you, Your Honor.
The court is addressing case number 21-147237. This is LVNB funding versus Brianna King. The matter is before the court under the filing of a general civil complaint. The court is in receipt of an answer, and my predecessor did set this on for a pretrial. And your appearance for the plaintiff at this time, counsel. Do I have counsel for LVNB funding under the suffix 7237? If you're on this Zoom, please say something at this time. This one is set for 10:30. What time?
10:04 is open on.
All right. That's an early call, so the court will come back to that matter. All right, the court is calling case number 21-140349. This is Consumer Credit Union versus Renee Lynn Prater and Renee Lynn Lavelle, also known as. The matter is before the court, my predecessor having set this matter on for a final pretrial conference date. Your appearance for the plaintiff on Consumer Credit Union. Right, do I have defendant in this matter, Renee Lynn Prater, also known as Lavelle? All right, we'll recall it in just a moment. This is mixed up. All right, do I have the parties on tox testing, Inc. versus City of Detroit? Anybody on tox testing versus City of Detroit?
I know they sent in one.
I'm sorry.
Tax testing.
Yep.
They were sending in a dismissal on that.
All right, the record should reflect that 21-149-338 Tox Testing Incorporated versus City of Detroit, that matter is noted as dismissed. Do I have biomolecular iteration versus Allstate on the Zoom? Say something if you're on this Zoom. Biomolecular versus Allstate. I'm aware, just for the record, I'm aware that in some of the files that are that were under Judge Brew, that people did not receive the proper notice regarding the Zoom that they should be going into. And so some of those matters may be related to a misdirection regarding the Zoom location. All right, the court is calling now Genesis Recovery versus Alrashur Holloway. This is before the court set for a pretrial, for a status conference, if you will. Any appearance on this matter? Genesis Recovery? All right, let's do it another way then. Ms. Patello, what case do you have?
Capital One versus Corey Poe, and I am representing Mr. Corey Poe.
And Your Honor, I'm here for Capital One Bank, Daniel Best, P58501.
All right, we're gonna make some progress then. All right, so what's the last four digits on that particular case?
7967.
Everything.
All right, this is case number 21-147967. This is Capital One versus Corey Poe. The matter is before the court, set for a scheduling conference, status conference on today's date. Your appearance for the plaintiff, if you will.
Thank you, Your Honor. Daniel Best, P58501 on behalf of Plaintiff Capital One Bank.
All right, thank you, Mr. Best, and good morning to you. And Madam Counsel, your appearance for the record at this time.
Deanna Patillo, P82378 on behalf of Mr. Corey Poe.
All right, thank you. So have you guys had an opportunity to talk about this? What's needed in order to bring this case to some form of closure?
We have, Your Honor. We are in active negotiations, relatively close to resolution, but we do need some time. Counsel and I agreed that we'd ask for 60 days discovery and have something set thereafter.
All right, that makes sense to you, Mr. Tello?
Yes, Judge.
All right. All right, so the court will formally grant discovery in this matter through the 20th of July. So 7/20/21. Of course, witness list would have to be filed 14 days hence. So we're looking at, and I don't have the August calendar in front of me, so that would put us August the 4th is what I think I should have. That would be okay.
No, that's a weekday. August 4th. You said August 4th?
Yeah.
That's a weekday.
All right, August 4th is the cutoff for the filing of a witness list. 2 weeks after that time, which would be the 19th of August.
18th.
August.
Mhm.
That's a good day.
Yes.
18th of August will be the time for filing of any motions in this matter. Responses to such motions would in fact be due in this matter by September Second, the court will set the final pretrial conference in this matter for the 16th of September. I will, and that's going to be at 9 o'clock a.m. And if you will chat your email address, we will go ahead and get this out to you by way of email, so you have the document scheduled in this case. Your next action date is September 16th, 2021 at 9 o'clock a.m. Now, certainly, if you get this resolved, you don't have to wait until September. You can zoom in any day as long as you have the other party consent or presence. You can just zoom in on any day and say, Judge, we'd like to speak with you. So don't wait around because you got a little bit of time. I know that you won't, but know that you have access to the court, either formally or informally. The order gives you a formal access, but informal is when the two of you agree that we need to talk to the judge. Please do so, please. Right.
We'll do so.
So if you can chat your email addresses, we will get that out to you. We'll get that out to you right away. And I see that I have received your chat, Mr. Best.
I sent mine. I'm sorry, I sent mine.
Did you chat your email?
Yes.
All right, got it. All right. So we'll get that out to you shortly, to the two of you. Thank you.
Very
Thank
good. Have a good day, Your Honor.
Have a good night.
Likewise. All right, I'm looking at, and Ms. Milburn, I see that you're back. I'll be with you in just a moment. Ms. Agarian, what matter are you here on, ma'am?
Yes, good morning, Judge. I'm here on the matter of Curtis Norman versus Mechanic Zone Auto Repair. I'm attorney for defendant.
All right, let me have the last four digits on that matter, if you will.
The last four digits are 0039.
All right, this is case number 21-240039. This is Curtis Lee Norman versus Mechanic Zone Auto Repair. The matter is before after removal from the small claims division, and is set on for a status and scheduling conference on today's date. Madam Counsel for the plaintiff, or sorry, for the plaintiff, please, your name. Do I have counsel or do I have Mr. Curtis Norman? All right, I'm looking for Curtis Lee Norman or plaintiff counsel for Mr. Norman. Mr. Norman, if you're there, say something at this time. All right, your appearance for defendant in this matter.
Yes, good morning, Judge. For the record, Marie Garian on behalf of the defendant, P13853.
Thank you, and good morning to you, Madam Counsel. Have you had any contact or any information with the plaintiff in this matter regarding today's hearing?
No, Judge, but we did submit an answer to the complaint along with a motion for summary disposition, and we have heard nothing from the plaintiff.
All right, just 1 moment, Counsel. You did not receive a previous scheduling order, did you?
I did not, Judge.
Just 1 moment.
You care about it?
I'm sorry, I have the phone.
Oh, you have it.
Yes. All right. I've had a chance to read the motion in this matter. Significantly, defendant has not appeared. The court did send out its date with its scheduling order. The court did indicate on that document failure to appear for this matter will result in dismissal of the claims, entry of a judgment by default, granting a relief claim, etc. It appearing, I'll ask once again, Curtis Lee Norman, Court Curtis Lee Norman, if you're on this Zoom, anybody representing that person. All right, it appears now that the plaintiff has failed to appear regarding this matter. Accordingly, that failure to appear will result in dismissal of this matter at this time. Okay.
Thank you, Judge. Should we prepare the order or will the court?
If you would prepare an order and submit it, that would be great. You can do that at the email address that I gave you, and we'll get
Thank
that
you,
back.
Judge.
That lady out there standing in the room. I'm like, who is she?
Yeah. Trucks down there. Finish my truck.
We're back on the record regarding the suffix 7502. That is the case involving Roberts Orthopedic Services versus National Union Fire Insurance Company of Pittsburgh. This matter is before the court for a final pretrial conference. Also, this was a date duly established by the Honorable Judge Brew as the motion hearing date. All right, and Ms. Milroy has entered her appearance as well as Mr. Fortner. Mr. Fortner, sir.
Your Honor, counsel and I had the opportunity to talk, and with the court's permission, we would ask that the matter be adjourned 30 days. Apparently what happened, Your Honor, was counsel did actually indicated the case, the motion was misfiled, and it was transferred to 36th District Court. We got notice of hearing, and counsel, I'm assuming, assumed that we would just assume it's the same motion, and technically speaking, I guess we could have, but I didn't realize that until we started talking today. And so I have a response to the motion. I can get that filed today. And we're gonna come back in 30 days and we're gonna see where we're at with the workers' comp side of things, and see if we can't get it worked out. If we can't, then we'll ask you to make a decision on the motion. But I can get my response filed as soon as needed.
All right, very well. All right, Ms. Milroy, that make some sense to you in terms of collegiality in this matter?
Yes, Judge.
All right, I'll set the matter over. I'll set the matter over 30 days. Hence, setting it then for the 17th of June.
June 17th.
Yes.
All right. What time?
9:30 a.m. June 17th. 9:30 a.m. will be the next hearing date. The court finds good cause to grant the adjournment, and you'll receive an order in that regard. All right. Good day to you.
Yeah, it's good to have you on the civil docket.
Thank you. Thank you. I hope all feels the same way, but
Judge, I apologize. I have a conflict on the 17th. Is there any way that you can?
What day works? What day works better for you during that particular week, counsel?
Yeah.
The week of the 14th.
Let me take a look here. My apologies, Judge.
I could set it later in the morning if that would help you. Or we could put it on a different date.
I could probably do the morning of the 16th or later in the morning on the 15th.
All right, well, let's put it on the 16th, and we'll set that time at 9 o'clock a.m.
All right,
Okay, great.
9 o'clock on the 16th.
Yes, June 16th, 9 o'clock a.m.
All right. Do we,
Judge, do you require a renotice?
No.
Okay.
all right.
No,
Cable out.
I'll get an order out, and that order will simply set the adjournment date. No renotice required. The motion is set on, the motion for summary disposition is set on for hearing on that date, and that is in fact the final pretrial conference date. All of it is adjourned until that date.
All right, thank you, Your Honor, very
Thank
much.
you so much, Judge.
June 16th, 9 o'clock.
Yes.
Yes, did I get that wrong? Is that's not messing with the?
No.
Actually, right. Yeah, I'm like, well.
All right, so let me see who's been looking at me for some time as well, just so that we follow. Mr. Johnson, I believe that you've been sitting there. What case are you on, Mr. Johnson?
Your Honor, the last four are 0367.
Just one moment. This is case number 21, 50367. This is CKS Prime Investments LLC versus Sharondale Kelly. And the matter is before the court, duly set on by the Honorable Judge Drew as a, looks like a final pretrial conference. Strike that as a pretrial conference date. All right, this court did generate this date as well. Your appearance at this time.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
All right, thank you, counsel. I did see also submitted in this matter was a request for a default judgment. Do I have a defendant in this matter?
Yes, Your Honor. Sharondale Kelly's here.
All right, thank you, Mr. Kelly, and good morning to you, sir.
Good morning to you as well, Your Honor.
Thank you. All right, so counsel, somebody submitted a proposed default in this matter. Update me on what the status of things are as you understand it, counsel.
I believe Mr. Kelly submitted a responsive pleading to the court via email. However, we never received a copy of that pleading, so we did send in the default. Obviously, since he did file it and we have a proposed settlement to place on the record, I don't want that default judgment to be entered.
Very well. And I do see, I'm looking at the response to the complaint, and it does seem like there was some effort here by Mr. Kelly to say that it should be resolved. Tell me what the resolution looks like regarding this matter.
Your Honor, Mr. Kelly has agreed to pay a lump sum of $1,293.46 on or before July 20th, 2021, which would result in a settlement of the case. After we receive the funds and they clear the bank, we would send a stipulated order of dismissal with prejudice to Mr. Kelly for his review and signature.
All right, Mr. Kelly, is that something that makes sense to you, sir?
Yes, it does, Your Honor.
All right, then the court will in fact approve the settlement regarding this matter, and the court will sign an order consistent with the same. That is that upon satisfaction of the amount, with the due date being July 20th, 2021, the matter will in fact be dismissed in this regard. Right? That is the resolution in this matter.
Your Honor, can we have a control date just in case something falls through the cracks with the payment?
Yeah, I was thinking about the same, and kind of the way that I favor these situations. And if both parties doesn't agree that it doesn't work that way, and that is to enter an order of conditional dismissal pending final dismissal. And that order of conditional dismissal will set forth the terms, and that order becomes final unless becomes final unless reinstated. The plaintiff would have the right to reinstate without motion. Would have the right to reinstate and for entry of judgment if the payment is not made as agreed upon.
Okay, I will send that proposed order to Mr. Kelly for his review.
All right, Mr. Kelly, you understand the nature of the order that the court is proposing?
Yeah, from my understanding, Your Honor, it sounds like basically if I fail to pay on time, it just allows things to proceed as if we had completed this hearing today with the original default.
Basically what happens is that if you, as long as you abide by the terms, it's a conditional dismissal. After the 20th, it becomes a final dismissal upon the payment. If the payment is not made by the 20th of July, then the plaintiff can submit a judgment, and in that judgment, it will say case is reinstated and judgment is entered on the complaint. That judgment on the complaint will be for the amount in the complaint. It would be for the amount greater than the $1,293 that's been agreed upon. So the ideal here is to keep the agreement. The case becomes finally dismissed. That works for you?
Yes, yes, Your Honor.
Yeah. It seems to be consistent with what the parties want to do here, get it resolved. So counsel, you can submit the order with that language. And Mr. Kelly has on the record indicated that language works for him. So as long as it's paid $1,293.46 by the 20th of July, 2021, the conditional dismissal automatically turns into a final dismissal. If it is not paid, then the plaintiff will submit an order of judgment, and that order of judgment will say case reinstated, judgment entered based upon the amount pled in the complaint. There'd be no further hearing necessary in this matter.
Okay, I will email that order to Ms. Hunter.
All right, thank you. And make sure that you email a copy to Mr. Kelly. So get his information. If you don't have it, I can put you all in a breakout room where you can chat it to Mr. Kelly, whichever way.
If you don't mind just putting us in a breakout room briefly, Your Honor.
I see, Mr. Johnson, that you are efficient.
Oh, thank you, Your Honor.
Yeah, let's do it that way. I agree. Let's just go to the breakout room and get this done. All right, very well. So I'm giving you number 2, Mr. Kelly. You're getting a notification from me to go to breakout room number 2 as well. So,
okay.
For some reason, I don't see you coming. Okay.
Okay.
All right. It's a contest between Mr. Goodman and Mr. Rossi. You guys will be honest and tell me who was in this room first.
I think Mr. Goodman was here first.
Mr. Goodman, which case are you on, sir?
I'm here on Bright Financial versus Riley.
The last four on that, sir.
9808.
All right, this is case number 21-145-689. This is Midland and Credit Management versus Anosha Guy. And the matters before the court set for a pretrial scheduling order. The court did receive an answer regarding this case. Your appearance at this time, counsel.
Judge, I don't believe that's the correct case number that you called.
What's your last four? Your last four again? I'm sorry.
I'm here on 21-149808 GC. Should be Bright Financial Services versus Debbie Annette Riley.
Maybe it's me that's getting a little fogged up this morning. So give me those last four digits again.
9808.
I see what's happening here. I have it right in front of me and it's stuck in another file. Sorry about that, sir. it was inside another file.
No
This is case number 21-149-808. This is Bright Financial Services Incorporated versus Debbie Annette Riley. The matter is before the court, set on today for a status and scheduling conference. The court did receive a document styled as an answer statement filed on or about April the 13th of 2021. Counsel, your appearance for the record, sir.
Good morning, Your Honor. Robert Goodman appearing on behalf of the plaintiff. My P number is 55670.
Thank you, counsel. And I'm looking now for Debbie Annette Riley. If you're on the Zoom, please say something at this time. I see a mouth moving, but I have no sound. So if that's you, Miss Riley, just unmute yourself. *6, I think is what.
I am
All right,
here.
what's
Can
your
you
name?
hear?
Yeah.
I am
What's your
Debbie.
name? You broke up a little bit. What's your name? Say your name for me.
Debbie Annette Riley.
All right, thank you, Ms. Riley, and good morning to you, ma'am. All right, this is a general civil complaint that's been filed alleging some damages in the amount, I think in the amount of some in excess of $5,000, $5,875.70. Have you spoken in any effort to try and get this resolved at all, Mr. Goodman?
Yes, yes, Your Honor.
All right, that's Ms. Riley talking. All right, have you gotten it resolved? Have you been able to talk about this at all? Mr. Goodman, let me hear from you. I'll come back to you, Ms. Riley. Mr. Goodman?
Okay.
Yes, it's my understanding, Judge, we talked in a breakout room and that the parties are going to agree to a consent judgment in the amount of $5,875, a $75 filing fee, and a $43.31 process service fee. Ms. Riley has some financial inability to pay right now, so we were not going to put any payment terms in the consent judgment. And then hopefully when her situation improves in the next 3 to 6 months, she would contact our office and try and work out a payment arrangement.
Ms. Riley, is that the agreement that you wish to enter into resolving this matter at this time, ma'am?
Yes, I just need time to find a job. That's all. And then once I get myself back on track, I'll be able to try a payment plan.
All right, and so you're not disputing at this time the indebtedness. You just you're going to enter into the judgment and then get some time so that you can start managing it in the future. That about the size of this, ma'am?
Right, yes, because I get a voluntary repossession. That's what I did. So, you know.
I didn't hear that last thing you said. You said something before.
I did a voluntary repossession, Your Honor, because I could no longer afford the note. So they came and took the car and they sold the car. And whatever they sold it for, the remaining balance was what they said that I owed.
Yeah, that's a deficiency balance. Yeah. All right. Well, these have been some tough times, ma'am. I will allow the order by consent resolving this matter, and I'll sign off on an order. And I do, pardon me, I do wish you well going forward as you try to regroup, as I know that you will, and then try to move forward with tackling the obligation. So I will be signing the order upon its presentment to the court. All the best to you, Ms. Riley. Thank you, counsel. Good day to you.
Thank you, Judge. I'm going to email that document to her today. She provided me with her email address. She'll return it, sign it, return it, and then we'll send it into the court right away.
Sounds
I don't know
good.
if Your Honor, do you want to put maybe a control date of 2 weeks or something?
Well, I really don't, because I think that and I'm not doing that, but I think that the order is clear enough. If you, and Ms. Riley, I think she hung up, but if you don't get it returned, then just submit it as a consent, consent on the record.
Okay, thank you, Judge.
Thank you, counsel.
Have a good day, Miss Riley. Good luck to you, Miss Riley. You can call my office if you need anything, okay?
So Ms. Riley, you want to get that,
Okay.
you want the order back as soon as he sends it out. And if he doesn't get it back in a week or so, then what he's going to do is simply submit it and say there was agreement on the record. All right, you understand?
Okay. Yes, sir.
All right. I wish you well, man.
Thank you.
Thank you.
All right, Mr. Rossi, what are the last four on your matter, sir?
Good morning, Your Honor. 0058.
That's someone that was in the timeout room.
This is case number 21-150058. This is Carlos Williams versus Metropolitan Group Property and Casualty Insurance Company. The matter is before the court on the setting of a status and scheduling conference in this matter. Your appearance at this time, counsel.
Good morning, Your Honor. Chris Rossi, appearing on behalf of defendant Metropolitan.
All right, thank you, counsel. For the plaintiff in this matter?
I don't see the.
have-
Oh, sorry.
Go ahead, sir.
I don't see the plaintiff on here. It's Felzone Law and Richard Brewer. I've had a lot of cases with them. I'm sure if they had noticed, they did. So.
Yeah, I'm sure that they are not just deciding not to be here.
Right.
So your take on this, is some discovery needed, or can this get resolved without some discovery? What's going on, sir?
This is a first party PIP case, and I do need discovery on this. This is a new one, and I don't have the claim file on this yet. It's a fairly fresh case. I just would ask for 90 days. I've sat through your call here. I know you prefer 60, but I have, like I said, I have a good relationship with plaintiff's counsel. I'm sure we'll get through it, but I just would ask for a little time to take the depth.
All right, very well. So I will go ahead and set the. I will go ahead and grant a 90-day horizon for discovery in this matter. That will set the matter over for discovery completion on August the 20th, 2021. Exchange of witness lists will occur on before September 2nd. And you'll get this in writing, counsel. And motions, any motions in this matter would have to be filed on or before September the 2nd as well. Any plaintiff, strike that, any response to respective motions, such responses would have to be filed on or before the 16th of September. The motions timely filed. The motions timely filed will be heard on September 26th. Make sure that date is good. September 26th.
27.
Huh?
27.
Oh, 27. September 27th, 2021. That's going to be at 9:30 a.m. 9:30 a.m. will be the next hearing date regarding this matter. And counsel, if you will chat your email address, and I will get this out to you, and we'll send a copy to plaintiff's counsel, but you can also follow it up with sending something out to them.
Sure, be happy to do that. Thank you very much.
I do see that you chatted your email address, and we'll get this right over to you, sir.
Thanks so much. Have a great day.
Likewise to you, sir. Just one moment. All right, let's see who I have here now. I call a case where I see Miss Guy. This is case number 21-145-689. This is Midland. Midland Credit Management Incorporated versus Anosha Guy, excuse me. The matter is before the court set for a pretrial scheduling order status conference at this time. Do I have the plaintiff in this matter, plaintiff's counsel regarding this matter at this time? All right. Your name for the record, ma'am?
My name is Anosha Guy.
All right. Thank you, Ms. Guy. Good morning to you, ma'am.
Good morning.
I see that you did file an answer regarding this matter, and in your answer, you indicated you do owe the plaintiff in the amount set forth, but Home Depot refused to settle with you for a lesser amount. You contacted their representative to settle the case, explained to them they're no longer working, etc. And it's further says, I'm willing to settle the debt for a lesser amount and monthly payments of $50. All right, so you made an offer of settlement. You haven't heard anything back from anybody, is that true?
Yes, that's true. I haven't heard from anyone.
Okay. All right, so I am not sure as to why they're not here today. I just got on this docket. So what I'm going to do, let me do one thing first, and that is I'm going to have someone to call their office and see if I can get them on the Zoom. Because basically, it sounds like what you are interested in doing is trying to see if we can get this resolved, reach some agreement and compromise. Is that correct?
Yes, that's correct.
So let me see if we can get them on to come on the Zoom. So my clerk is going to reach out to them, and I'll come back to you in just a moment. Right?
Okay, thank you.
All right. So I'm looking at Gilbert Davis. I see a couple of people. Mr. Davis, Gilbert Davis. Mr. Davis, if you're there, say something. You have to take your device off from mute, Mr. Davis, if you're going to talk to me. You have to hit *6. Okay, I see someone up there, LG Style 4 is what your phone indicates. Tell me who you are. Yes, right there, ma'am. Yes. Lady with the glasses on there. Good morning to you. Say something to me.
Good morning. My name is Rebecca Kokalis, and I had a case against Budget Lot.
Just one moment, Miss Rebecca. What's the last name again?
Kokalis, Kokalis.
0198.
And just one moment, Ms. Capellas. You said 0198.
Yes.
All right, this is case number 21-240198. This is Rebecca Kokalis versus Budget Lot Incorporated. The matter is before the court set for a status and scheduling conference. This was a case that started out as a small claims and then was removed to the general civil division. I'm looking, just one moment, ma'am, at your complaint where all right, where you claim the amount of $5,997.70 in your complaint. Is that correct, ma'am?
Yes.
All right. So have you spoken with anyone from Budget Lot? I see that they have an attorney involved in this, but I don't see that they are in the Zoom today. Have you spoken with anybody? Anybody reached out to you?
No, nobody's reached out to me.
All right, so.
Other than I did get a letter stating that they were moving it to civil court.
Right, yeah, and that's why you're in front of me, because they, by law, they have the right to remove it from the generals, from the small claims to general civil, and that's what brings it in front of me, okay?
Yes.
All right, so I'm gonna reach out to them and see why they're not here. I just got assigned to this docket, and so some folks have been slow to be able to get the notice, but you got it. So I want to reach out and find out why they're not here. So I'll get back to you in just a moment. So just hold tight there, Ms. Capellas.
Thank you.
Kokalis, I believe it's pronounced, correct?
Yes.
All right, gotcha. And this guy, we're still checking on that matter.
I called twice from this guy.
I'm sorry.
From this guy, I just called twice. They aren't answering the attorney's office.
All right, very well. So, Ms. Guy, I'm not getting an answer from that office.
Yes.
So here's what I'm going to do, ma'am. I'm going to give it an adjourned date. I'm going to give them a chance to come in and talk about resolving this matter. If they don't show up at the next date, then we're going to dismiss the case.
Okay.
So that next date is going to be, can we do it in 2 weeks? I may be away the week of the 21st of June. So
Okay, okay. So did you want to do the 9th of June?
June 9th. So that's going to be the next day, June 9th, 2021. And that's going to be at 9:30 a.m., ma'am.
Okay, let me see. Let me just check my calendar.
So just zoom back in on that date, June 9th at 9:30 a.m.
Okay.
All right. Thank you, ma'am.
All right. Thank you so much.
Can we see what each other, just see if there's anything going on? I'm looking at last name Bryant. Last name Bryant. You on the Zoom? say something if you're there. Last name Bryant, M. Bryant.
Yes, I'm here, Judge.
All right, so what case are you here, sir?
You heard my case earlier, Judge. I just haven't signed off yet. I was on the Ailman versus Sedesco case.
Gotcha. I remember that. Okay. Just
And
making sure.
you've commented a few times about wondering where some people are. Just as a FYI, I never received a Zoom notice or any order or notice of today's hearing either. The only way I knew about it is I got a telephone call from plaintiff's counsel, Jim Toth, who informed me that there was a hearing scheduled this morning before you, and the case had in fact been transferred to you from Judge Blue. And that's the only way I knew about it. I never received any notice for this morning either, just so you know.
And that's some of what we're trying to work with. You're absolutely right that we're having some of those kind of challenges. So yeah, we're trying to work. I had notices sent out, but I think we're still dealing with some mail issues, et cetera. So thank you for.
I just want to tell you that I was one of those, but I was thankful enough the plaintiff attorney notified me of it. So just FYI.
Yeah, and that's one of the reasons why we're not taking any kind of hard stand on folks not being here today. I'm basically doing read notices if I can't reach them at their offices, because I've been on this docket before, and the lawyers that practice here, they show up for court, so you kind of have to go with the reality that lawyers that normally show up for court and all of a sudden they're not showing up for court. Well, there's something didn't connect,
Okay.
All right, thank you, sir.
You bet.
All right. We're Ms. Cocales, we are calling their office to try to find out what may have happened, and if we can reach somebody, we'll try and get them into the school.
Okay, thank you.
No ringing, no answer for these turns.
All right, so we try to reach out to this office and have been unable to make contact with anybody. So I'm gonna go ahead and adjourn it because of, you've heard some of the things that I've been talking about here about the notices and the change in docket. I was just changed to this docket a couple of weeks ago. And so I'm not gonna set it out far. I'm gonna go ahead and bring it back on the 9th of June. And we're gonna get another notice out to them, the 9th of June at 9:45. 9:45, June 9th.
Okay, Your Honor. Thank you very much.
All right, and I wish you well, ma'am. All right, we'll see you the next day.
Okay, bye-bye.
Number one.
I gotta figure out how to hang this up.